What's the primary purpose of awarding damages in a breach of contract case? We explore that question in Krafsur versus UOP. El Paso Refinery, which we'll refer to as the debtor, owned a petroleum refinery. UOP developed and licensed petroleum refining technology. The debtor and UOP entered into licenses that allowed the debtor to use UOP's technology. Because the licenses were unit-specific, they couldn't be used at another refinery. The debtor then filed for bankruptcy. The term lenders foreclosed and conveyed the refinery assets to a newly formed company, Refinery Holding Company, or RHC. RHC operated the refinery using UOP's technology. UOP claimed that RHC's conduct violated its intellectual property rights. UOP then entered into separate licenses with RHC, pursuant to which RHC agreed to pay $3.7 million in royalties. UOP filed a claim in the bankruptcy proceeding to recover, among other things, approximately $1.9 million in royalties that the debtor owed under the original licenses. UOP's claim was essentially one for breach of contract. Andrew Krafsur, the bankruptcy trustee, objected and asserted that UOP had been made whole through the licenses with RHC. UOP argued that it was entitled to recover the unpaid royalties because it was a lost volume seller. A lost volume seller is one that has such a large supply of goods that it could have sold to both the breaching buyer and the second buyer. And here, UOP claimed that it could have sold licenses to both the debtor and RHC.